I think everybody by now would be used to the virtual meetings. And so it's really literally is just a reminder. We would ask that your name is properly displayed on the face of the screen, as well as we ask that you mute your mic, that everybody mutes their mic except for the persons who are speaking. So when we come to the discussion session and persons want to ask questions or make comments, we would then ask you to unmute your mic and to introduce yourself. There is, of course, the features that are available, which is a raise hand feature, which indicates when you need to ask a question or to make a comment, and you can wait to be identified. There's also the chat feature, which you can either go directly to an individual or just have a general chat to everybody in the session. So having gone through those preliminaries, I would ask for all our members to stand so we can have the national anthem, and then I'll get into the meat of the matter as to why we're all here this evening. Apologies, it's muted itself. I would just like to welcome everybody again to the sensitization session for Justice of the Peace. I would like to especially welcome our Minister, the Honorable Mr. Delroy Chuck QC, MP, who will be kind of overseeing the activities that are being put on by the ministry. Special welcome as well to Her Excellency Marianne Van Steen, who is the ambassador, also the head of delegation for the European Union for Jamaica and Belize. We would like to welcome all our custodes, and a special welcome to the Honorable Bishop Conrad Pitkin, who will be bringing our prayer in a couple of minutes, as well as our permanent secretary, Ms. Grace Ann Stewart McFarlane, and our Chief Technical Director within the ministry, Mrs. Curry Beckford. A special welcome to every single Justice of the Peace, our custode who is here this evening. We look forward to a very informative session, and as I had indicated, we'll be following along the lines of the agenda. Again, my name is Renee Oliphant, for persons who may just be coming in, and I'm the Senior Director of Justice Policy Analysis and Development at the Ministry of Justice. Bishop Pitkin, if you could possibly open your mic and grace us with a prayer.
Thank you, Mrs. Oliphant. Good evening. Just a few verses from the scriptures. Psalm number 62, verse 1 and 2, and verses 3, 5 and 6, sorry. Truly my soul waiteth upon God. From him cometh my salvation. He only is my rock and my salvation. He is my defense. My soul waiteth thou only upon God, for my expectation is from him. He only is my rock and my salvation. He is my defense. I shall not be moved. As we go to prayer this evening, we pause to reflect on God's goodness, on his grace, and on his mercies towards us as a people. So note that we want to remember and pray for those who are hurting this evening, those who are grieving because of the loss of a loved one through the continued senseless murders in our country. Let's remember our government as we ask God's divine guidance and wisdom upon our Prime Minister, his cabinet. Pray for the Honorable Minister of Justice and his team, and for the work that they have been and are doing. Let us pray. Our gracious Father, we approach you this evening in confidence, confessing that you are our God, and we recognize none other but you. We offer our praise and our thanksgiving. We thank you for our beautiful island home. We thank you, O God, for the blessings that we enjoy coming from you. Even in the midst of the challenges that we have, we are confident that you will take us through our difficult times. We remember those who grieve today, those who mourn, those who are hurting emotionally because of the loss of a loved one, a friend, family member who have lost their lives because of the senseless killing and the barbaric behavior of some. We pray for comfort. We pray for peace. We pray that you soothe their sorrows and heal the emotional wounds. We ask that you remember our Prime Minister and his cabinet as they lead this country. We ask, God, that you'll continue to grant them and grant especially a Prime Minister guidance, wisdom to lead in this difficult time. Remember our Governor General, the leader of opposition, our members of parliament. We present them before you today. I pray this evening, Lord, for our honorable minister and his team for the sterling service and commitment of the team to country, to nation. We give you thanks for them. We ask for your continued strength for our minister as you guide him, as he guides his team. This evening, as we are gathered, just as the peace from across parishes, custodies, others, I pray that you will guide us. And at the end of this evening's deliberation, Father, we will be greatly informed that you will receive the glory and we will leave here with greater knowledge to do service to your people. Grant this we ask in Jesus' name. Amen.
Amen and amen. Thank you very much, Costas
Bless you,
Pitkin.
man.
Um, yes, it was a lovely prayer, and we look forward as we look at the service, human service that's provided by our Justice of the Peace, to just expanding your capacity to continue to serve our country, Jamaica land we love. Now, I know my background might be a little dark, but I just encourage you to listen to my voice and I will lead you through the proceedings in case you can't see me as clearly. We're at the stage where we're going to be getting remarks both from the Ambassador of the EU as well as our Minister of Justice, the Honourable Mr. Delroy Chuck. I would start with Her Excellency Marianne Van Steen, the Ambassador as well as Head of the Delegation of the European Union for Jamaica and Belize. Her Excellency, Ms. Van Steen.
Thank you very much. Can you hear me?
I can hear you very clearly.
Okay.
Welcome.
I had some problems connecting, but I'm very happy you can hear me. And I would like to start with giving some greetings. Honorable Mr. Delroy Chuck, Minister of Justice, Honorable Mrs. Tricia Dunwell, Custos of St. Andrew, Mrs. Grace Ann Stewart McFarlane, Permanent Secretary, and of course the Justices of the Peace for Jamaica. A real pleasure to be here with you and other stakeholders and especially invited guests. I wish you all good evening. Let me start by saying that some 6 years ago, the European Union decided to provide grant funding to assist the government of Jamaica to reform its justice sector. And also because we firmly believe that a well-functioning justice system is an important step to ensuring equitable and efficient access to justice. And access to justice, as you all know, is essential in any peaceful and well-functioning democracy. So indeed, our support was, we decided that this was a valid request, that this was useful, and there had also been a joint review of the justice sector just before that revealed that there were endemic problems that hampered the system's ability to deliver justice for all in a timely manner. So that review at that time pointed to the lack of the use of technology in case progression, to the limitations regarding access to justice for certain parts of the population, and to significant backlogs at all levels of the court. And so we came in, and our quite substantial funding has allowed the European Union to collaborate with the government of Jamaica, and in particular with the Ministry of Justice and with Minister Delroy Chuck in particular, always having in the back of our minds the importance of a rights-based approach and a commitment to ensuring equitable access to justice for all. So that was like 6 years ago. We have worked very hard. Let's say that in particular, the Ministry of Justice has worked very hard. We spend a lot of funds as well, but not only from the European Union, also Jamaican taxpayers via the national budget of Jamaica has invested a lot. And we're actually quite pleased with what we have seen. We're quite happy with a number of very tangible results. And if you know me, I will just mention a couple. One of the first points was to improve the efficiency and the accountability of provided to those in need. But let me just highlight two of the key achievements of the program that may be of particular interest to you, the Justices of the Peace. Notably, on the one hand, the establishment of 12 justice centers across the island and the mainstreaming of child diversion within the sector. The latter two points that I mentioned contributed to increase the access to justice by providing avenues for alternative conflict resolutions for cases either referred to by the courts, the police, or through personal referrals for discourse that have the possibility to resolve conflicts and bring, hopefully, lasting peace within communities. all of that is the good news. However, despite all these improvements in policies, practices, and service delivery within the justice sector, we also have seen that lasting peace and citizen security is still eluding many persons, and we do indeed have noted increases in acts of violence, especially in the recent months. This is very regrettable, of course, and it's also one of the reasons why I accepted the invitation of the Minister of Justice to address you this evening, because I have understood that the justices of the peace are the first points of contact with the justice system for many, many, many people, and that makes your role so crucial. Recent acts of crime have shown that there are still too many who think that they should or they can take justice in their own hands. And it are indeed the justices of the peace that can contribute to breaking this subculture of revenge. Your closeness to the people provides an opportunity to inform about diversion, mediation, restorative justice, and other alternative discourses. I very much would like this opportunity to invite you to do so. Many persons still do not know their rights under the law, and also they do not realize that even those rights must be balanced by individual and social responsibilities they have themselves. And your role as advocates for peace can actually, so we think, contribute to filling this gap. So my invitation to you is to continue to contribute to the improvement of each community you serve by taking justice to the people. I truly believe that the cascading effect of your efforts, your integrity, and your acts of impartiality can shape the landscape for the people you serve, especially for the youth. So that is my invitation to you. I'm extremely grateful to see you all connected together in this very important event. And I wish you a lot of courage and a lot of strength to continue the good work that you're doing. Thank you so much for your attention.
Thank you so much, Ambassador Marianne Van Steen. Very insightful words, and I think it would be remiss of me not to, on behalf of not just the Ministry of Justice, but also the people of Jamaica, to thank the European Union for their contribution to Jamaica, not just to the justice sector, but we're here as a ministry having benefited significantly from the input that has come in from the EU. So thank you again on behalf of the people of Jamaica. I would just like to take this time as well to remind everyone to mute their mics. Please mute your mics. As we go forward, we would like to reduce the number of interruptions. I did hear that there were a couple of persons who seem to be having challenges hearing. And just to indicate that if you're having a challenge through this medium, that there are other means of access. And these include the PBC Jamaica, their YouTube page. You can access it through that mechanism, as well as the Ministry of Justice's Facebook page. So if you're having a challenge with this live stream or with coming through WebEx, you can go through our live stream pages, the PBC Jamaica YouTube page, as well as the Ministry of Justice's Facebook page. Without further ado, I'd like to ask that our Honorable Minister, Mr. Delroy Chuck, Minister of Justice, bring remarks to the sensitization session. Minister Chuck?
Thank you very much, Renee. And first of all, let me thank Bishop Pitkin and also Ambassador Marianne Van Steen for her short remarks and very important remarks. Ambassador, you spoke to over 700 JPs who are on the live chat with us, and I am sure that many others have joined us on PBCJ and also the Ministry of Justice live stream. I want to thank all of the Justices of the Peace who have joined us. It is our first training and sensitization session for 2022. We're going to have many more because we believe that we must empower you, the JPs, so that you can give accurate information to the people that you serve. It is very important for all of you to improve the quality of information that circulates across the island. And that is why on a regular basis, we will have these sensitization sessions. There are so many issues that we would like to bring to your attention so that you can assist not only your neighbors, but all the people that you serve. One area that will be coming up very shortly is the digitization of our currency. We're going to have a central bank digital currency, that's a CBDC. And it is important that you, the JP, not only use it, but you encourage others to use it, but you may be the person who assists them in using it. Again, we're going to have the NIBS, which is coming on stream very shortly. And once again, you, the Justice of the Peace, will be asked to assist us in getting persons signed up with a NIBS card. What is also very, very interesting, JPs, is that I have been able to negotiate that or that you live in the country. There are many justices of the peace who have migrated and have not informed the customs. So this annual report will indicate that you're still alive and well and still serving. Even if you did not serve for the year, still send in your annual return. Moreover, unless you send in the annual return this year, when the NIDS card is produced, even if you say you're a GP, unless you have registered and send in your annual report, the Custos or the Ministry of Justice will not be able to tell the NIRA, that is the National Identification Registration Authority, that you are a JP. So it is important that you send in the annual report so that we can verify that you're actually a JP. That is important. This evening, in addition to further sensitization on the Justice of the Peace Act, we're also going to be stimulating you on land matters. And I know the JPs have problems or get questions about land matters. So we have two outstanding members of the National Lands Agency, Miss Charlene Lofton and Sarah Daly, who will be addressing you on land matters. And you have the opportunity of asking questions, communicating. It might be very useful when they're addressing you to send written questions so that they can compile it. Because when the question and answer comes, may not be able to get on. So it's useful if when they're speaking and you have a question, you actually put it on, send it in a written form. May I just say that this particular website, we can communicate with just about 1,000 persons, and we're fast approaching 1,000. So a number of persons who may be trying to get on, please if they call you and ask if you've gotten, tell them it is on PBCJ, because it might be over 1,000 or it might reach 1,000, and then it can take no more. Future sensitization, justice of the peace. We're going to ask you to send us some indication of what areas you would like us to speak about. But I know that there are several areas that I would like to suggest to you, but I will do that at another time. Over the most of 2022, as Ambassador Marian Van Stein said, we have to concentrate this year on ADR, Alternative Dispute Resolution. Far too many in our communities are using, abusing, violence, and murder to settle their arguments. We must find an alternative way to settle disputes, to restore relationships, to avoid conflicts, and even if we get in conflicts, to be able to settle them peacefully. So that is why we have the justice centers all around the island, and these justice centers are supported by the European Union. They are supporting the Ministry of National Security to reduce the amount of violence across our communities. And we must show, Ambassador, and all the European and all our international partners that we are benefiting from the input that you have given to us. So I'm begging all of you to participate in as many training programs in restorative justice, mediation, child diversion, and victim services, because these are the alternative dispute resolution methods that we hope to bring to our people and let them have a better understanding of how to resolve dispute. And in truth, as I go around, I was asking the justice of the peace to work out a good relationship, not only with one another, not only with other stakeholders in the communities, but with the police, because crime is our major problem at the moment, and every single one of us can play a part. Next week, we have the National Restorative Justice Week, and the theme of the conference, the week, will be preventing crime through restorative justice is everybody's business. I'm going to ask you, if you can, to participate as much as possible or listen to some of the addresses. And I hope you will all play your part this year as we all try to make Jamaica a better place. Now, I want to thank you all and hope, and I'm sure you will have a good evening. I will try to be on and to respond to any questions that you may have at the question and answer period. But for now, please listen carefully to the presentation. So thank you for joining. Back with you. I am with you, but I will make myself available at the question and answer time. Thanks, Renee.
Thank you very much, Minister Chuck. And I thank you on behalf of the ministry as well for acknowledging our partners from the National Land Agency, which I had not done at the beginning of the session. So welcome to our session. Ms. Shalene Lawton and Ms. Sarah Bailey, who are going to be giving us a presentation on the role of JPs and land matters, as Minister Chuck had noted. We're going to be going into the presentation section now, and what we're seeking to do is actually to empower our justices of the peace with information on areas of significance. So you heard Minister Chuck speak about the whole issue of, submitting our annual reports. We're going to have Mrs. Sylvia Collins Duncan, our senior policy analyst acting at the Ministry of Justice, speak to us about the Justices of the Peace Act. And following that, we will then have a presentation from the National Land Agency, our sister agency, and they will be speaking, both Ms. Lawton and Ms. Bailey will be giving us a presentation on the role of JPs and land matters. Mrs. Collins Duncan, the floor is yours.
Thank you, Ms. Oliphant. Are you hearing me?
Yes, we're hearing you. Go ahead.
Okay.
Yes, hearing you.
Yes,
Right. Good evening, everyone.
Good evening to you, ma'am.
Welcome to our sensitization session, where we're happy to have you with us. As you were informed just now, we are going to be doing selected sections of the Justice of the Peace Act 2018. Well, for most of the seasoned JPs, you would have been familiar with the Act already, but there are some others who are not so familiar, and it is our duty at the ministry to keep you updated. For those who are already familiar, please treat this as a refresher. Okay? So this evening, at the end of this session, you'll be sensitized in relation to 6 objectives, and they are on your screen. Number 1, duty to provide service free of charge. The use of the official seal and the process for JPs to report lost, stolen, or damaged seals. The submission of annual reports to the custos. The obligation of a JP to notify the custos of any changes to his or her particulars, code of conduct, and lastly, the offenses. So we're going to be providing an overview of these sections. Okay, before we go into the
Not hearing a thing. Not
objectives,
hearing anything.
let me just say that there are 2 particular laws that every JP needs to know. Please take this as your Bible text. And these laws are the Justice of the Peace Act 2018 and the Justice of the Peace
Not
Official
hearing, not
Seals
hearing. There's
Regulations.
no sound.
Turn up your You are hearing. Something is wrong.
I'm hearing.
Hearing.
Audio clear on my end.
My
Audio
audio
clear.
is loud and clear.
Okay,
Loud and clear
can you
as
hear any
well.
better now?
Audio clear.
I am hearing.
Okay. Okay, thank you. Let me just repeat.
There, I'm hearing okay.
Thank you. Let me just repeat. These 2 laws are your Bible. Number 1, the Justice of the Peace Act 2018, the Justice of the Peace Official Seals Regulation. Why do you need to know these 2 pieces of legislation? These are the ones that will guide you in the execution of your duties, right? It is very important that you become familiar with them, because we want to avoid any commission of any breach by any of you because you did not know. All right, so we need for you to understand clearly what is expected of you and what your duties are. All right, JPs. So the first objective we're going to be looking at is that of the JP services
Is
being
anybody
provided
hearing me?
free
Because
of
I'm not hearing
charge.
a word Mrs. Collins is saying.
I am hearing.
Excuse me, can
Okay,
you mute one,
everybody
please?
else is hearing. Can you please check on your end,
Ladies
sir?
and-
Everybody
yeah.
else is hearing.
Ladies
You
and
need to check
gentlemen,
your audio.
thank
Turn off
you.
everything else.
Thank you. For the gentleman who is not hearing, I would suggest maybe that you sign out and try to sign back in, or that you try to join us through PBC Jamaica or on the Ministry of Justice's website, because I think it might be a challenge that you're experiencing individually.
I'm sorry, can I add, when I join?
Okay, thank you very much. So the first objective that we're looking at is the matter of JPs providing services free of charge. And for this, we will look at the section 15 of the JP Act. For avoidance of doubt, it is hereby confirmed that the office of the JP is not an
Mrs. Collins Duncan, you're no longer, you seem to be muted. And based on the fact that we have so many persons on, I would just crave your indulgence and ask that perhaps we could turn our cameras off. That might grant us a little more bandwidth, if possible. Thank you very much. Ladies and gentlemen, we crave your indulgence at the ministry. They seem to be having a slight technical glitch, but we are working assiduously to get it back on track. Mrs. Collins Duncan, are you hearing us? Okay, even though I have absolutely no control over the PowerPoint, perhaps I could speak to the slide that is currently before us. And what it speaks to is the provision of the services of the Justice of the Peace free of charge. I'm going to turn my video off. I'm being prompted to do so. Mrs. Collins Duncan, are you back?
Not as yet, Ms. Oliphant. We're still having some challenges, so just proceed. Mr. Hofstede will move the slide along.
All right. So sections 5, 10, and 11 speak to the official seal of the JP. And as you can see, on section 5, subsection 4C, upon appointment, each JP will be entrusted with an official seal. And I'm sure every single person here who has been appointed a Justice of the Peace has either gotten their seal in hand, or if it's a recent appointment, it is in train. Section 10.1b speaks to the justice using the seal solely for the execution of the functions of the Justice of the Peace, that is, of the office. And so section 10.2 specifically states that you shall not use any other seal other than the official seal assigned to that JP. So, let's say, for example, you left your seal at home and one of your co-workers wants, to sign a document, or a Justice of the Peace down the road. Please send them to that individual rather than going and borrowing the other individual's seal. Utilize the official seal that has been assigned to you. Section 10.4 speaks to the fact that a Justice of the Peace shall cease to use a seal if they retire, if they resign, or if they're suspended from office, or if the appointment of that JP is revoked as based on the directions of the custos. So in these instances, section 10.4 speaks to when you are not supposed to be utilizing that seal that has been given to you in your capacity as a Justice of the Peace. So when we retire, when we resign, if we're suspended from office, or God forbid, the appointment of the JP is actually revoked. Mr. Hofstede? Okay. So the official JP official seal regulations in regulations 3, the amendment was done in July of 2019, and it actually deleted the reference to the parish on the seal design and replaced it with Jamaica. As you know, previously it would have been the parish to which you were assigned as a Justice of the Peace, but as you can see, it actually just stipulates that design in the middle of the screen, which says Justice of the Peace, and you're serving the country of Jamaica. All of the other features have been kept, except, for example, that alphanumeric parish code that you would have been granted on your appointment as Justice of the Peace. Next, and this comes under Regulation 3. All right, going on as well. So in using the official seal, the design of the seal is also not to be modified or distorted. We recognize that this is a potential security risk, and so the official seal, the color is actually neutral. So everybody who has their seal, you know, the imprint that is affixed and through the actual seal that's affixed onto the paper, and so it is actually color neutral. We can move on to the next slide. All right, so lost or damaged or stolen seals are actually dealt with under Regulation 7 of the JP Official Seals Regulations. And Section 7.1 says that where an official seal is lost, damaged, or stolen, the JP must make a report within a reasonable time. And a reasonable time is, I don't want to say that it's subjective, but we encourage you at the soonest opportunity to contact the custos using the prescribed Form 1. And this is of importance because that form actually translates, is sent to the Ministry of Justice, and it facilitates the discussions in relation to the replacement of that seal. So we encourage it, if it is either lost, damaged, or stolen, that you make that immediate report to using Form 1 through your custos. The custos is required to notify the Permanent Secretary of the Ministry of Justice, forwarding a copy of the JP's report. And usually what this will stipulate is what happened in relation to the seal, whether it was lost, if it was damaged, it was stolen, as well as a recommendation as to how it could be treated with going forward. Section 7.4 actually stipulates that the custos shall forward to the PS, the Permanent Secretary, any damaged official seal that is in his or her custody using Form 2, as well as sealing any seal that is in his possession other than damaged seal. So there are situations, for example, where Justice of the Peace might be deceased, and so the seal is now in the possession of the custos, that this should be forwarded to the Permanent Secretary forthwith as well. Next slide. I'm seeing the questions that are coming in, and we'll treat with them in the discussion section. Okay, and here, as you can see here, this is just a depiction of what Form 1 looks like, and it actually sets out the information related to the name of the custos, and really what this facilitates is the provision of information to the Ministry of Justice as to what would have happened in relation to a lost, damaged, or stolen seal. Next slide. And this is just a replica of Form 2, which again is sent in by the custos to the Permanent Secretary. And these are really just standard form documents which are utilized as a means of record for the Ministry of Justice through our Permanent Secretary. Next slide. We're getting to the meat of the matter now, which is the JP's annual report. I saw a couple of questions that had been raised in the chat earlier in relation to the time frame for the submission of the annual report. And this is stipulated to be the 31st of January. What you'd be doing, as you can see on the Section 7, is that you're required to submit to the custos a report which is completed in the annual report form, and this is to be submitted by January 31 of the next calendar year. So basically what you're doing is reflecting or reporting on activities that you would have undertaken as the Justice of the Peace in the preceding 12 months, or depending if it's shorter than that, the preceding time that you had been appointed as JP. Where a Justice of the Peace does not meet this requirement, that is setting it in by the 31st, they may be required to resign office, or a recommendation may be made for the revocation of that JP's appointment, and that is done by the custos. But again, we really don't want that. It's a standard form document. It is very simple, extremely simple to complete, and we would encourage every single Justice of the Peace, if you've never done it before, please make 2022 your year that you actually submit it, and submit it on time. That is by the 31st of January. Section 7, subsection 4A, speaks to the custos shall in writing as well remind the justice of the peace of their obligation to comply with the requirements. And I know that all of the custodies would have been making contact with the justice of the peace in their parishes and just encouraging them to ensure that that report is submitted and submitted on time. As I said, it's a standard form document. The forms are available through your custodies, and we would encourage you to just fill them in as quickly as possible and send them in. We really would prefer the carrots. We really, prefer not to have to utilize the stick, which is spoken or referred to in 7.4b. Next slide. And again, here you heard me speak of the form, the annual report for the Justices of the Peace, as you can see. Very, very simple. And really what we're seeking to elicit is information on the work or the activities that you would have engaged in during your time or your service to the country as a Justice of the Peace. And that's captured close to the bottom of the page where it says, you've been unable to, well, it speaks to what you've been unable to complete, what you actually have done, and you get an opportunity to indicate, areas that you might be interested in engaging that you might not necessarily have done before, but that you'd want to provide service to the country. And of course, any other relevant information. Next slide. Now, I will tell you, this is a little more difficult for me to see. But again, this is just kind of reflecting the information. And Julio, can you pop in? Unfortunately, I'm not able to see the top part of the form.
What you'd have seen before would be the prescribed form, and this form that you're looking at now is the same form, but it is the electronic version. So if you should visit the Ministry of Justice's website at www.moj.gov.jn, then you will see this form and you can download it and you can enter your information electronically. Unfortunately, you will not be able to submit it electronically, but you can plug in your information and print it and submit this form to your custos.
Okay, thank you very much. That was Mrs. Moncrief Wigan, who is an active participant or part of that process related to the appointments and general management of our Justice of the Peace. I'm assuming, based on the fact that the presentation has vanished, that was the last slide. Am I correct, Julio?
It is not. We're having some challenges. Apologies, custodies and justices of the peace. So what we'll do is just continue along with the program until we're able to sort out the rest of it.
Okay. All right. Well, is it that your challenge relates to presentations generally, or would we be able to go to the presentation that's being done by the National Land Agency?
That's right. Let us try the National Land Agency.
Mm-hmm. Okay. And it just as a follow-on, actually, the last sections will relate to just a reminder of the notice for the annual report, your obligation to notify the Justice of the Peace if there are any changes. For example, you've moved abroad for half of the year, any other, changes that may have occurred to your situation since your time of appointment, your expected code of conduct, actionable conduct, and that's related to the third. Oh, here we are. So you will see here the reminder of the annual, the notice of the annual report. And this is something that you will see reflected through advertisements through our local media. But just as a reminder, it's Monday, January 31st, 2022. That is the final date for submission of the annual report for the Justice of the Peace for the preceding year. Next slide. All right, so section 16.3 of the Justice of the Peace Act speaks to an obligation of the JP to notify the custos of any changes. And really what you're expected to do is to notify the custos in writing on becoming aware of any change in respect of any particulars that's required to be contained in the register under subsection 2 in relation to that justice. So, change of circumstance. We would ask that I'm seeing, Miss Bowie, that you said the slides have disappeared. Is anybody else experiencing that same challenge? No.
No, still
Okay.
same.
All right. Miss Bowie, maybe we might need to sign in and then come back, sign out and then come back in. So section 16.3 speaks to just really literally signing in and letting your customers know if there are any remarkable changes that need to be made to the register in relation to you as a justice of the peace. Next slide. There's a code of conduct, which is also set out. Section 7 speaks to observing the provisions of the code of conduct, as failure to do so could constitute misconduct. You're also encouraged every year or on the Ministry of Justice's Facebook page who would fall into any sort of misconduct that would require action being taken either by the Custos or the Governor General. So we encourage you to be aware of what we expect of you as Justice of the Peace, not to charge for your services, and just to try to comply with the requirements that relate to the annual report. Of course, there is a situation where criminal proceedings or other pending things could also be a means of tainting the reputation of the Justice of the Peace, and we would want to ensure that these are avoided at all costs. Next slide. Section 12 and 13 of the JP Act speaks to revocation. And again, as we noted before, it's in relation to the failure to submit your annual reports or conduct which taints the office and is or likely to bring the office into public ridicule, cause a public scandal, or bring the administration of the Justice of the Peace process into disrepute. That's under the third schedule of the legislation. And I think that might be it. Thank you very much for your time, and we crave your indulgence again. Thank you very much, Mrs. Collins Duncan, for the creation of the slides. And we will have our questions. We noted the ones that came in on the chat, but we're going to go to the National Land Agency. And then at the end of it all, we'll have our general question and answer section. Oh, just further note, on summary conviction in a parish court, there is a fine of up to $500,000. There is imprisonment of up to 3 years, or both fine and imprisonment. And again, we said none of our JPs will be falling into this category. And the offenses speak to using your official seal for an unlawful purpose, allowing any other person to take possession of the seal or using it for any fraudulent purpose, as well as using the official seal after retirement, resignation as a JP, or revocation of your commission by the Governor General. So that information is actually reflected in section 9(1)(a), B, and C. For 9.2b, which speaks to failing to report damage, destruction, loss, or theft of the official seal in accordance with the regulations. There's also a penalty. It's a fine of up to $250,000 or imprisonment of up to 6 months, or both the fine and imprisonment. There's also a situation which is recognized under the legislation, which speaks to failing to return the official seal after retirement, resignation, or revocation of the commission by the Governor General. So if in any unfortunate incident, we may have a situation where we've retired, we've resigned, or our commission has been revoked, we would encourage you to return the seal forthwith so as to avoid being summarily convicted in a parish court. And you can see the penalties that are listed there. That's it. Thank you very much for your time. All right, I'll put on my other hat, which is as chair of the proceedings. And as I noted, questions can come at the end during our question and answer section. We're going to give our sister agency representatives, Ms. Shalene Lawton, who is the Adjudication Services Manager for the National Land Agency, and also Ms. Sarah Bailey, the Legal Officer for the Land Titles Division of the National Land Agency, an opportunity to speak on the role of JPs and land matters. Welcome, ladies. I hand the floor over to you.
Good evening, everyone. Slot will be introducing us today.
Good evening, Ms. Bailey.
Ms. Lawton, are you with us?
I think Ms. Lawton might be having a slight challenge with your audio.
Her microphone is muted.
Okay. We will action that.
Thank you. Good evening, everyone. I was unable to unmute my microphone. Everyone hearing me?
Thank you and welcome. Yes, we are hearing you. Welcome to our sensitization session.
Okay, good evening once again. So today we'll be looking at the role of JP and land matters. And Sarah Bailey and I will be presenting. We are covering several, well, not several. We are covering topics of execution of documents, transfer lost titles, unregistered land, adverse possession, and negligence, just the common areas that starts with that the JPs will encounter during their day-to-day operations. Sarah will do the first part of the presentation, and I will look at the last part, which is negligence and the precautions that you need to adhere to. Sarah, ready?
I'm ready.
Sure, go ahead.
So, execution of documents that are to be submitted to the National Land Agency should be done generally pursuant to Section 152 of the Registration of Titles Act of Jamaica. The persons who are allowed to execute those documents under this section of the Act are the Governor General, who is duly appointed at the time, any of the judges of the Supreme Court, any Justice of the Peace commissioned to act within the island of Jamaica, the Registrar of Titles commissioned under the said Act, a Notary Public commissioned to act, or a Solicitor of the Supreme Court, which is an attorney at law who is called to the bar in Jamaica. Next slide, please. I'm sorry, someone from the ministry is sharing their screen. Would you prefer if I share mine?
That's all right. I'm seeing. Everyone is seeing?
Oh, okay.
No.
All right.
Good.
Miss Oliphant, is everyone seeing our...
Well, I'm not sure for everyone, but I'm just seeing a circle going around and around and around. So I'm not sure if everybody else is having the same challenge as me.
Could persons in the chat just let us know if they're seeing... Oh, my volume is low. Am I better now?
Yes, you are.
Okay, great.
Go ahead and we'll try to keep up, Miss Bailey.
Please share in the content.
Okay.
Sarah, we are not seeing.
We'll just ask you for a couple of minutes while we get it back up and running. Ms. Lawton or Ms. Bailey, if possible, you can continue speaking. I've been indicated or been told by the Ministry of Justice they'll catch up with the screen. You're now muted again, Ms. Lawton. Okay, we crave your indulgence, ladies and gentlemen. I think we might be getting it up and running. Ms. Lawton, you're still muted? Yes. MOJ team, is this something that we can assist with? Non-muting Ms. Lawton, since we seem to have lost Ms. Bailey, but perhaps Ms. Lawton could continue. Okay, I'm noting that Ms. Bailey, this is for MIS's information, Ms. Bailey is muted and she's unable to type in the chat. So is it possible from our end to unmute either Ms. Bailey or Ms. Lawton?
Hi, everyone. Can you hear me again?
Yes, we are.
Great. My apologies for that. Are you seeing my screen?
We are, yes.
Okay. So documents are also that are to be executed. Documents that are to be submitted to our offices can also be executed pursuant to the Voluntary Declarations Act. Some documents fall under this act because they are considered declarations from the persons giving them. Such matters should be completed pursuant to the form listed in Section 7 of the said Act. Examples of matters that would be considered declarations and should be witnessed by a justice of the peace pursuant to the said Act are applications to surrender title under Section 77 of the Registration of Titles Act, applications to note death, applications to note marriage, applications for first registration to bring land under the Registration of Titles Act, applications for lost title, dispensation of title application, applications to correct name, and general statutory declarations that are requested from justice of the peace from time to time. One way of identifying if a matter is a voluntary declaration or falls within the scope of that act is it usually has, well, it should have an attestation clause, and it tends to have the wording of made and subscribed under or pursuant to and taken and acknowledged by. Now, the attestation clause as set out in the Act that must be on these documents are, or should read as follows. And I, or if it's multiple persons who are doing this document, and we make this solemn declaration conscientiously believing the same to be true under and by virtue of the Voluntary Declarations Act. The person or persons who are giving this declaration must sign that instrument before the justice of the peace, and the justice of the peace must then sign acknowledging that he has witnessed this document being executed, and he must apply his embossed seal. Execution of documents that are outside the scope of, It's unlawful for justice of the peace to deal with matters that they do not have jurisdictions over. Example, witnessing documents that they did not see the person signing, they are not familiar with the person who is alleged to have signed this document, and are doing so merely because someone has asked a favor, etc. Further, where persons are either ill, unable to read or write because of illiteracy, blindness, or some disability, then what is known as a marksman clause is to be used on the document. That marksman clause is to read that, is to indicate that the instrument that you are witnessing was read over to the person who is purporting to sign it. And it was explained to that person, and that person indicated that they understood what the contents of the document were, understood the nature of the document, and the effect of the contents of the document. So they understood the effect of them signing the document, what that would mean for them. Another type of document that is often witnessed by or justice of the peace is the transfer instrument. Now, transfers are used to change ownership of land. Now, to do so, if the land is registered, ownership is changed by way of a transfer instrument. If the land is unregistered, ownership is changed by what is known as a deed of conveyance. All right? When someone sells or purchases land, the process of a transfer is done, or a conveyance is done, to change the ownership from the person who is known as a vendor or seller to the person who is a purchaser. When land is gifted from one person to another, a transfer or conveyance is still required. It's just that one person is no longer the vendor, they're just the gifter or grantor, and the other person is the recipient of that gift. But the documents needed to transfer ownership remain the same. If it's a gift, it's a transfer by way of gift, or a deed of gift, or a deed of conveyance by way of gift. Justice of the peace are usually called upon to witness these documents. So witness the person signing to indicate that they understand that they're relieving themselves of their ownership of the land and passing it to another person. Or witness the person who is taking ownership of the new land to say that they understand that they are taking ownership of the land from the person who is giving or selling it to them. Or agreements for sale, which are documents, or sale agreements, whichever way you refer to them, which are also documents that form a part of this process. The other type of application that oftentimes justices are called upon to witness are lost title applications. Now, when a justice of the peace is witnessing a lost title application on behalf of a layperson, that is, a person who is not an attorney or is not represented by an attorney, that is what we mean when we say a layperson, they are required also to prepare a statutory declaration. That declaration must state whether this justice of the peace knows this person who is signing the document before them and how long they have known them for. And if they are not known to this justice of the peace, then they must also indicate what form of identification was produced to the said justice of the peace to satisfy them that the person who was signing the document was who they purported to be. That identification must be indicated in the statutory declaration. That is, you must state what type of identification. So if it's a driver's license, you say so, and the number on the of the identification. So if it's a driver's license, you list the driver's license number. It must also, the application must also be supported by a current passport size picture for the applicant. And that picture must be certified by the said justice of the peace who is witnessing their application, right?
Everyone hearing?
Yes, go ahead, please.
All right. It seems Sarah had a difficulty, so I'll continue. So in first registration, that is the application that we use to bring land under the Registration of Titles Act, meaning the land has no title. So when persons are trying to get a title for their land, the proper name of the application is Application to Bring Land under the Registration of Titles Act. So Jamaica has over 800,000 parcels of land recorded on the valuation roll. And of this number, 300,000 of these parcels are unregistered. What it is, not having a title does not mean your land is not recognized and you are not the owner. It is just that a title is the highest form of ownership that you have. The word that we use in law is to say that the title is indefeasible, meaning once you have a title, someone will have to come with a lot of evidence or proof to defeat that ownership. So you will be on the tax roll paying your taxes, but it does not mean that you have a title. Next slide, please. In 2005, this one is the long name. That's what we call it. The Registration of Titles, Cadastral Mapping and Tenure Clarification Special Provisions Act. We call it the SPA for short, was enacted to provide the legislative framework to address the land tenure issues rooted in our culture, which adversely impacts land registration. So what does this mean? In 2005, the government recognized that, listen, we have a lot of land. These lands are unregistered. Persons are not coming forward to do the registration for several reasons. So we are going to use this piece of legislation to enable them to be able to get the registration done, make the process a little easier. You still pay, but it's at a lesser cost. So for example, you are exempted from subdivision approval, transfer tax, stamp duty, and death duties, but you will have to fall within a project area, meaning within the area that has been declared under the SPA. Next slide, please. So looking at this SPA, you have section 1, subsection B, which provides that an applicant is required to prove 12 years of opened, undisturbed, and undisputed possession of the land. So if you can prove to us that you're on this land for 12 years, 12 continuous years, you know, so you cannot be in possession year 1, year 2, then you went away. Going away meaning you just did not do anything with the land, year 3, year 4, and then you turn back up now, year 5. Year 5 will restart the clock to year 1. Adjudication committees were established under the SPA to adjudicate issues concerning the rights and interests in land. So the adjudication committees consist of 5 persons. You have the chairperson, who is an attorney at law called to the bar for 10 years, a commissioned land surveyor, 10 years in practice, the justice of the peace, usually within the community or the locality of the adjudication committee, a community representative, and a minister's representative. And just to add that the adjudication committees are done along the electoral boundary lines. So you'll have Manchester South, Manchester Central, Clarendon North. So we will be always try to get the justices that are within those electoral boundaries. And it helps because they will know the individual, the community rep is from the community. So when persons appear before the adjudication committee and give their evidence to say how long they have been in possession, chances are persons on the committee, because they are associated with the locality, will be able to verify if this is so. Next slide. Within the first registration process, we have what we call adverse possession, which is title acquired by possession. And I think this is a piece of legislation that every Jamaican knows. So Section 85 to 87 of the Registration of Titles Act was enacted. For a period of time, you acquired a possessory title, you would even defeat the Trespass Act because you are on this land. When the Registration of Titles Act came into effect, it adopted this section and made it applicable now to registered land. So for registered land, you have to prove 12 years of possession. So if you're on the land for 12 years, meaning you're there, you have fenced the land, you're farming, you probably bush the land. Some persons will plant callaloo, quick crops, graze cattle on it, animals, etc. Once you have shown your act of possession, and it is registered land, you need to prove only 12 years of occupation from the commencement. So you start with occupation January 1, 2000, and then you count off until you reach the 12 years. Next slide. Please, thank you. If the land is unregistered though, meaning there's no title for the land, the person who is claiming the possessory title will have to show 20 years. You have to prove that you have, 30 years. You have to show proof that you are in occupation for 30 years. So based on this, you know that a person of 40 years old will not have a claim. And let me tell you that the year starts counting when you turn 18. So even if you were born on the land, you're a minor. You attain the age of majority at 18. So year one is when you reach 18, that is when the clock starts running for you. So be mindful of that. So it's not when you were born on the land, it's 30 adult years on the land. Next slide, please. All right. So we went through just now what you needed to know when you're executing, just to familiarize you with the transfer, the lost titles, and the first registration. So this is the part now where the justices will get into uncomfortable situations if they are not paying careful attention. So I cited a case where negligence was held to be the valid cause of an action, and it involved both an attorney at law and a justice of the peace. Because what it is, the justice of the peace witnessed a forged signature of a registered proprietor. And in the case, damages meaning money, were awarded, where the loss was sustained by the registered proprietor was identifiable and measurable. Next slide, please. Thank you. So the elements of the case were simply this. A owed a duty of care. A duty of care was owed by the defendant to the plaintiff. So the plaintiff is the one who brought the case, and the defendant would have been the attorney and the justice. There was a breach of that duty by the attorney and the justice, and the damage to the client was what resulted in that breach. So the person lost their home. Next slide, please. The case is Graham and Hall, and it's a 2006 decision. It says H and W were entitled. H presented a mortgage deed with W's forged signature to his attorney. The signature was witnessed by a justice of the peace. Both attorney and the justice of the peace were held liable for negligence, and damages were awarded in terms of 60% to be paid by the attorney at law and 40% to be paid by the justice of the peace. So what it is, the case, the essence, what is the critical element of this case is that when the judge went through the evidence, it was determined that the attorney at law and the justice of peace ought to have exercised a little more care. They should have been more vigilant because they just got this document. The signature was forged, it was witnessed, and it would go towards identification issue, etc. Next slide, please. All right. The court held that a registered proprietor's interest in the property is obvious and that the risk of harm arising from a forged signature is a foreseeable one to an attesting witness. The fact that the registered proprietor is a stranger to the attesting witness does not negate the duty of care owed by the attesting witness. So you realize what the judge is saying here, It's not good enough that you're going to say, oh, I didn't know him. You got the ID. So you have to look now on the signature on the ID. Look to the signature before you. Look at, sometimes I'd look at the body language of the person who is coming before you. This is not somebody that you know. And even more so, you're more in danger of people you don't know from people who you don't know. So I will come to you and say, oh, my sister signed this. Just witness it for her, man. She signed it. Do you know my sister? Do you know her signature? To be so familiar with it, to be able to look at the document to say, did you sign it? Or better yet, what is your sister's phone number? Let me give her a call just to verify something. You call the sister, you say, sister, Charlene is in front of me. She has a document asking me to witness her signature. Did you give this to her? It is what you have to do to protect yourself as you operate in this environment. Next slide, please. In the previous case I just mentioned, the facts of the case were undecided as it's surrounding the witnessing of the mortgage. So there was no deliberation really as to the circumstances under which the witnessing took place. The issue was that the justice of the peace was found to have breached his duty of care regardless of which scenario had actually taken place. So you notice now what the case is saying. It's not even for the justice to say, oh, I was tricked, or it was a scam, or I was gullible. No, the court said that the duty of care lied solely at the feet of the justice of the peace in terms of the verification of who is in front of him. Next slide, please. So when you're exercising duty of care, just some pointers for you to take with you. Attorneys and justices of the peace are therefore encouraged to be vigilant in the exercise of their duty of care as attesting witnesses where instruments are lodged for registration with the titles office. In the normal course of business, the witnessing of signatures may be handled in a certain manner as a matter of convenience to the client or the registered proprietor and in the interest of time. Attorneys and justices of the peace must, however, take precaution to ensure that signatures are in fact made by the registered proprietor. Earlier on in the presentation, when Sarah spoke about the lost titles, the lost titles application, you see if a lost titles application comes before you and it is being done by a lay person, meaning a non-attorney, you need to be very, very vigilant because the lost titles application are the vehicles of fraud. It is like, the articulated buses that the JUTC have with a rubber thing in the middle, the long ones. Just look at that. That is how big the vehicle of fraud is when it comes to lost titles application. Because what persons will do, they will say, oh, the title is lost. Submit an application, that title that is in office is now cancelled and a new one is issued. They would have collected the new title. So you will be at home with your title saying, oh yes, I have my title and I'm okay. And it was cancelled. And when it was cancelled, it was subsequently sold. Now, your remedy as a person, and I'm speaking to you too as an owner, so not only as a justice of the peace, but as a landowner within your own right, or your family member, or your friends, whosoever. When that title is taken by fraud, the remedy you have is against the person who committed the fraud and not the person who purchased your house. So A owns the land. B defrauds A and sell the land to C, the property. C, with all good intention, thinks that B is really A, and that B is the person who is authorized to sell. When A finds out that C is the owner, A cannot go to C and say, give me back my house because I did not sell it. A needs to find B and tell B to give him or her back the money that B earned from fraudulently selling the house. And trust and believe, B would have long disappeared. So fraud is a very heart-rending situation. It's painful. And you know that we're a country that has a challenge with resolving our difficulties in an amicable matter. And we know that when it comes to land, people will get violent. So we have to be very careful, especially when it comes to the lost titles, especially when you see a lost titles coming with a transfer. Hence the reason why we require, when the matter is done by a lay person, that the justice of the peace who witnessed the document does a declaration to say that he either personally knows the person or the ID was presented to him. Next slide, please. Here are some precautions that we wanted to adhere to as well. Establish and adhere to a procedure for the identification of signatories. So have your own little routine that you do. Each person is different and you're going to have a system that works for you. Ensure that each client presents an original valid government issued photographic identification, driver's license, the electoral ID, the national ID, the passport. You see, for persons overseas, they have this thing where they give you their green card. A green card is not an identification. If it's an overseas identification, their passport and their driver's license is accepted, but not a green card. We know that the electoral ID finally expired December 31, 2021. So you are not to do anything with the old ID. If they don't have an ID, you cannot assist them. Don't let them photocopy or scan or go on the phone and show you a download of the ID and say, oh, this is my ID, I have it scanned. No, you want to see the physical ID. Yes, it's COVID time, but you need to actually touch that ID. Look at it. I would even tell you to go as far as rub your fingers over it to see if the ink is coming off. We are a creative people. And as best as possible, where you can keep copies of these identification for your records. So what I know some justices do, they actually have a notebook or a diary where they write in it the day that who they witness, the document that they witness. And they take a picture of the identification and store it somehow for their files. Next slide, please. Ensure that the signatory signs in your presence. If for any reason he does not do so, a quick telephone call to the signatory to confirm his knowledge and consent is necessary. So notwithstanding you know the person, and notwithstanding you know who is sending it, unless the person told you beforehand that I'm going to ask so-and-so to take something for me and I'm asking to witness it, you would have made that arrangement. So this is a judgment call on your part. So anytime you get that niggling of doubt, that little voice in your head, do not ignore it. Usually that is the voice that is warning you that something is wrong. Critical to the witnessing of documents now. Your signature must be on the same page as the signatory. You either sign the witness beside them or below them, but never above, and never on the next page. So the signatory cannot sign on page 2 and you are witnessing on page 3. Even if there's no space there, squeeze it in. As Jamaicans would say, catch it up, put it there. But if it is that your signature is not beside or below the signatory, the document is going to be rejected because it was not properly executed. As I said earlier, pay attention to the signatory's behavior. You look at the body language. You just observe. And if it's anything that appears suspicious to you, you have the right to decline or request further information. Be vigilant where the signatory's urgency is unwarranted or where the signatory appears uninterested in the legal implications of a document or where the signatory refuses to attend your offices to sign. So you know you have some persons, everything for them is quick, 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 quick. Oh, sign this to me, sign this to me. No, 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 quick, quick, quick. No, be careful of that. Because before you even witness the document, you need to look through it to see exactly what it is you're witnessing. You need to have a look, oh, all right, this is a lost titles, you are, etc. So don't let them dictate the pace at which you operate. Because oftentimes when persons start rushing you like that, they are not of good intention. Next slide, please. All right, preserve as is your duty, and it was just discussed earlier, just to reiterate, preserve and maintain the safe custody of the seal. So report loss of theft or theft as soon as possible to the police and to the registrar of titles. So in all your other responsibilities, you send a letter to the registrar and you say, my seal was lost, this is my seal number. Any document that comes in for me dated after this date, I did not witness it. You need to let us know, because when we see a document sealed, duly sealed, with the impress sealed, issued by the Ministry of Justice, we're not going to question if your seal is legitimate. So you need to tell us if your seal was compromised, and then we will know to put a pause on all documents. And we can even call you to verify, is this you? Did you witness it? If the transaction involves jointly owned property and communication is predominantly with one of the joint owners, we have a problem. Two persons are entitled, they are joint tenants, meaning they have unity, they have to move together, they have to act together. And one only comes to you, you have never met the other one, you have never spoken to the other one. You need to ask clearly, what is the other person? So I would even say maybe this would require you to even ask them to take a copy of the title to you, and you look at it to see who are the owners on title. And this is especially for persons who you don't know and you're working with just the identification. I can't say this enough, pay special attention to lost titles and transfers. These are the instruments that people use, and they normally twin the lost title with the transfer in the case of fraudulent activity. Next slide, please. Attorneys and justices could also do the historical check of the title to see for potential inconsistencies. I'm not sure how many persons are familiar with a title, what it looks like, how to read it. But if you are, or if you know have a colleague who knows how to do so, reach out to them and verify, because this can assist you in also doing your job. You are to independently obtain contact details for the physical address of the property and contacting the owner using those details. So these are instances where you're in doubt and you're just not comfortable with what is happening, because the physical address of the property is not necessarily on the title now. What is on the title is what we refer to as a property address. So for somewhere like Mona, you will not see on the title Mona, or better, it says Papine Estates. So you have to know So if you are looking for 3 Rosemary Drive, then the title may say all that parcel of land known as Beaumont Hill. So you will never see Rosemary Drive in the description because you have what we call the property address, which is the address of the land, and you have the civic address, which is the address that the postman knows that you come to when you're doing your mails. So you must ensure that your seal accords with the regulation. So it doesn't matter if wherever you go and get a seal made, for us at the NLA, we need to see the impress sealed. Try and seal it as best as you can so we see the number. If we're unable to see the number, sometimes we shade it with a pencil for it to pop up. But there are times even when you shade it, because there was no pressure applied with the sealing, so it's very faint, we'll send it back for it to be resealed. And this was before we removed the requirement for the parish to be stated, but we require the parish then. So now you're a justice of the peace for Jamaica. Next slide, please. And that's it. That's the end of the presentation. And we'll take the questions now as it relates to the presentation that we just did. If the questions is in the chat, Ms. Oliphant, I'm going to ask you to help me to navigate the chat so I can get all the questions.
Okay, we do have some questions in the chat, and we've been going through them. I think what we'd also ask persons to do is possibly just to raise their hand. We'll treat with those first, and as we go through and disseminate the ones. A lot of the questions in the chat related to whether we'd be getting or providing the presentation, and yes, it will be provided to the persons who are participating. So perhaps we can ask for persons. Thank you very much, Ms. Lawton and Ms. Bailey. It was a very
Your daughter reached an in the
interesting presentation, very insightful, and I'm sure the Justice of the Peaces would have been able to appreciate some of the rigors that are associated with them carrying out their functions as JPs. We see there are situations where persons could be penalized as a result of not necessarily doing their due diligence, and we'd encourage them to do that. So we'll just ask persons perhaps to just put their hands up, and then we will then take the questions verbally while we go through the chat just to identify the questions that would have come in relation to the National Land Agency in the chat. Julio and team,
okay, so
perhaps you could assist with the hands.
The first raised hand is Miss Pettigay. Miss Pettigay, please go ahead. Okay, so please bear with us. Parties were muted. Mr. Hofstede, if you could unmute the parties. Okay, go ahead, Ms. Pettigay. While we wait on Ms. Pettigay, Mr. Paul Moses, would you like to try?
Are you hearing me?
Yes.
Go ahead.
Yes, I am.
Okay, fine. So here is my question. Oftentimes, see where two of the persons who could sign legal document is a notary public, JP, and others. What's the difference between a notary public and a Jamaican, and who the notary public is as for guide?
What is the difference between a notary public
and a JP?
And a JP, all right. So you know Jamaica has notary publics. Their service is not free. And in Jamaica, notary publics are attorneys. As far as I know, they are attorneys at law. So for some international documents, they specifically ask for a notary public, so you have to get it notarized. But most time, our justice of the peace, it's a similar function. What is used is based on your locality, your region. So the European countries, the North American, to include USA and Canada, they have notary publics. But there are some documents, if the justice witnesses it and it goes abroad, it is accepted. But the notaries are not free.
Okay, let us try that. Ms. Pettigay. Ms. Pettigay.
Sorry, but I don't really have a question.
Is this Ms. Pettigay?
It appears to be, yes. She says she doesn't have a question. I think her hand was just up.
Okay, let us move on to, is this Colliber? Oh, I'm not seeing. I believe we have lost the parties. Okay.
Okay, so perhaps, as in the parties from the National Land Agency?
I'm
No,
here.
persons who have raised their hands. I'm not
Oh,
seeing
okay.
it anymore. We had quite a few, but I'm not seeing. Okay, I'm seeing Miss Delia Gillins McBean.
Yes, good night. Thank you very much for your presentation. I have some questions for the NLA in terms of the presentation. Are you hearing me?
Yes, I am.
Yeah, the first presenter spoke about the okay, in terms of when you see the document before you, and she was speaking about explaining what is on the document. And my question to her, I got the impression that it was a JP's responsibility to explain what is on the document. For instance, if someone comes to you and they don't know what they're signing, is it the JP's responsibility to explain? The other question I have relates to the proprietor, the registered proprietor. How does the JP, if the JP doesn't know the person personally, how does the JP, what will the JP have to do to confirm that this is actually the registered proprietor? And the other comment I had is in terms of when you spoke about historical check and precautions, and it seems that if someone comes to you with a title with this document to transfer, etc., there may be required that you do some amount of investigation to see, okay, well, that the title is what it is. And
that's a good question because it relates.
Sorry, I'm not finished, sorry. And it's a legal document. So I just want some clarifications on that. And I had a comment in terms of the SBA, but unfortunately, my pencil was out. All right, thank you very much. I'm trying to think there now. Thank you.
Mrs. McBean, so you have asked 3 questions. You have asked about the JP's responsibility to explain. How does the JP explain? And the historical checks and precautions. Am I correct? In essence, that what you're
yes, and in terms of what I mean, you spoke about historical checks, looking at the documents and everything, but in terms of us ensuring that what you have before you is the actual correct documents.
All right, let me take them. So in
other words, if someone is to come to me today to sign a document, it may take some time.
All right.
Done. Thank you.
So critical, let me answer that. Critical to the justice of the peace is the identity of the individual witnessing. That is your the most important role. In all honesty, by right, if this person is using an attorney at law, the attorney at law duty is to explain what it is. I'm hearing Wayne Lawrence. You're asking me something? The attorney at law. All right, let me finish answering her question. Let me finish answering Mrs. McBean. And then and the moderator will indicate to you when you are to speak. Right. So if if the document is being dealt with by an attorney at law, that is the attorney at law's role and duty. Your role and duty is to verify the identity of the person if this is somebody that you don't know. That is the critical thing. What often happens though in the rural areas, and the deeper you go into the rural area, the JP happens to be judge and jury and everybody. So people look to the justices to have the requisite knowledge to tell them what they are to do and what they are not to do. If you are not so possessed of this knowledge, just simply tell them you can't assist them as it relates to that. You can verify identity and witness the documents. Because remember, some justices have more experience in terms of doing, especially with land matters, and they would have been around it for a longer time. So it might come easier to them. If it is something that you're unable to do, that's fine. What your main focus is on the identity of the person before you. I think I've answered the one about how does the attorney explain. Historically now, if you're in the community and you know this house, you know it, you grow up there, you grow or you live there long enough, and you see this person come and telling you, oh, it is being transferred to them, etc. You know who the owners are. You reach out, especially if they carry the document to witness to you and the owner not there with you, you know. You say to them, hold on, you check who is selling you, when they're selling, and you can reach out to the owner to say, are you selling this property to so and so? So it's not that when we say historical check, if you are familiar with the titling process, you are familiar with reading the title, that's fine. But if you are not, and this is somebody that you know, there are other ways to do the checks. You can check around. So you know me. You know I own this land. You see somebody come now to purchase the for you to witness their signature as a purchaser. You see my signature as a transferor. You give me a call and you say, Charlene, you're selling your property. So that is what it is. That I answered you, Miss McBean?
Yes, you have. And I think you have also answered the question in terms of, is it you need to know the registered proprietor in terms of duty and care?
If it is that you don't know the registered proprietor, you just don't know, but they know that you're a JP and they come to your office with the document and they ask you to sign, you ask for the ID and that you just verify. You would have done your part. So if it is that they have presented an identification to you and with all due caution, you don't see anything wrong with this ID, it's a standard passport, the names are where they usually are, etc., then you witness the document, you'd have done your duty. Where you'd have failed is if the person comes to you and say, oh, witness this for me, and you say, all right, and you just witness it. Or you say, where's your ID? And they say, oh, you know, I forget my ID. I never know I need my ID. And then you just witness it. That is when you would have failed in your duty.
Okay, thank you.
You're welcome.
Can I just add, Charlene, can I just add something?
Yes, sir.
First of all, Charlene's explaining that well. I'm going to urge the GP, as Charlene has said, identification is very important. If you don't know the person, it is best not to witness. Just let the person know, I don't know you. I know you're looking for a JP, but I just don't know you. I agree with Charlene that if you see a passport that looks that's valid, ask the person. It might be able to get a minister or someone in the community who can verify that this is definitely the person. This is the person with the passport, because sometimes it's difficult to find a GP. So in those circumstances, the answer may you use the passport, and you should note somewhere that you use passport number so and so to witness the person. But if they come to you with an identification that you don't know at all, I beg you, do not witness the person, because That is how a lot of fraud takes place. They come with some fraudulent ID and they fool you, should I say. So be careful, and especially in land matters, if you're not sure, tell them it's best to go and see an attorney at law. Because that attorney at law, if he makes an error and commits negligence, then the registered proprietor can sue the attorney if necessary. I don't want any of you JP to be sued. Okay. So be very careful. If you're negligent in witnessing a signature and you don't know the person, you could be sued in negligence, as Charlene has explained. So I beg of you, as she repeats repeatedly, unless you know the person, do not witness his or her signature. Thanks very much, Charlene.
You're welcome, sir.
Okay, we have a question from thank you, Minister. We have a question from the chat, and that relates to, that's coming from Mr. Donovan Hansen, and it is asking Ms. Lawton to explain what are the implications of ownership in situations where you have a joint tenancy versus a tenancy in common.
All right. Joint tenants, they operate together. And I'm just giving you the basic non-legal terms. So you own the property, A and B, you have to buy together, mortgage together, sell together. When one of the joint tenants die, you do what is called an application to note debt. So you cannot will a property held jointly. There's no will in this purpose. When when one joint tenant dies, if there are 3 on title, the 2 who remains automatically, after they have noted the death of the person who died, becomes the owner of the property. Tenants in common now, we have shares in the property, so we own it individual in our own right. So A and B on title, A may own 50 half, because we use fractions for the shares, not percentage. So we use A may own half, B owns half, or A may own 2/3 and B owns 1/3. But whatever the shares are, so A can sell his portion, mortgage his portion, although the mortgage companies in practice don't really like doing that. They like when both parties are signatories to the mortgage, because if God forbid you're unable to pay and you default and they need to sell to recover their money, they will be able to sell without an issue. If you are tenants in common, when one person dies, their share goes to whosoever they willed it to. Or if there's no will, it falls into what we call intestacy, and they administrate on the property, and that person will get it. So that is the difference. So there was an instance recently, 2 persons were on title, one died, they were joint tenant, and the daughter of the deceased was inquiring because she thought that now that the person died, she would have gotten an interest in the property, and we had to explain to her no. The fact that they were joint tenants and one died, the one that remains is now the sole owner of the property. So that is the main difference between the tenancies.
Okay, thank you very much, Ms. Lawton. Mr. Hansen, I'm assuming that would have been a sufficient explanation. We'll move to the next question, which is coming from Justice of the Peace Audrey McIntosh. And the question relates to whether a lost title, so in the situation with a lost title, can a Justice of the Peace request a title search to determine ownership?
It goes to how far you are prepared to go. So if this lost title is being done by a layperson, and that's what makes you comfortable, that's fine. That's your judgment call. If it is being done by an attorney at law, the presumption is that the attorney at law would have exercised the due diligence and ascertain ownership, etc. So again, it goes to what you are comfortable with.
Thank you very much. The next question, or it's a series of 3 questions actually, that comes from Carol Deans-Vizina. The first one relates to whether So for example, someone adds a title or adds an individual to a title, for example, an adult child, is this deemed to be a transfer? The second question relates to if, is there any difference in relation to how this is to be treated or is treated with? And then the third one relates to whether there's a standard format to guide the justice of the peace in relation to a statutory declaration.
All right. Let me start by saying any process that adds or removes a name from a title is a transfer, except for when you're noting the death of the person. So even when you leave a will, you still have to transfer to the person. And that will attract the transfer tax of 2% on the consideration. That is if it is being sold, if it's for value, money, or on the market value of the property. So if you're not paying any money for it, you're giving it out of love and affection, or what we call a gift, you will pay the taxes, the duties, sorry, on the market value of the property. If monies are being exchanged, so even if the property is valued at 2 million, but you're giving it to the person for 500,000, the stamp office is going to assess it and let you pay the duties on that 2 million because that is what it is valued. So anything to add or move a name on a title is a transfer. And just so you know, when you put someone's name on a title, whether or not you did it because you were in love, whether or not you did it because it's your child, or you were just being generous, once they are a registered proprietor, they are an owner in their own right. And you don't just get up tomorrow morning and take off their names. You'll have to do another transfer, and that will require the person to sign. Now, if it's not a harmonious relationship, if things have gone south and we are not getting along, you may have to proceed to court to get a court order, explain to the judge, and hope that the judge is convinced by your arguments and get a court order to get this person off the title. So putting somebody's name on a title is not something you do lightly. You have to give it thought, because then you just don't get up and take off their names. And it is treated like a regular transfer. Just the only difference is that the consideration is by way of gift. And that means that when you get to the titles office, rather than paying 0.5% on the consideration or the value of the property, you pay a flat registration fee of $5,000. But for stamp office purposes, for revenue purposes, you pay 2% stamp transfer tax on the property. As it relates to the format of a statutory declaration, it is found in the Voluntary Declarations Act. And it always starts with, I do solemnly and sincerely declare and state as follows. And it ends with, let me look, the memory is not as good as it used to be. It says, and I, if it's one person or we, make this solemn declaration, conscientiously believing the same to be true, under and by virtue of the Voluntary Declarations Act. So the Voluntary Declarations Act has the format for the declarations, and that is the act that stipulates that it must be witnessed by a justice of the peace. So there may be a standard form, or it may be something that someone drafts from scratch. So what you look at more than anything else is the substance of the application and not the form. So just look to ensure that it starts by saying, I do solemnly and sincerely declare and states as follows, and it ends with, and I make this declaration.
Okay, thank you very much. We're going to go with one last question from the chat, and then we'll go back to persons who have raised their hands. So the last question comes from Lorna Williams, and she indicates that there's a situation where somebody is now deceased and the property is to be sold. There are two beneficiaries, a sister and a fiance, and one of the parties is indicating, and they were supposed to get a 50-50% benefit. One of the parties is indicating that they're not able to find the title. And so the question is, can an executor apply for a copy of the title?
In this instance, the executor is the only person who would have standing to apply for to do the lost titles application. So the lost titles application would have to come in with what we refer to as a transmission application, which is moving the property from the deceased to the executor. and the transfer. So the law status application would be done by the executor in his or her capacity as the executor, and it must be comes with the transmission application, and the grant of probate must be there because the grant of probate, the deceased registered proprietor. And it happens all the time.
Okay, thank you very much. I'm guided by the personnel at the ministry in relation to the Mrs. Moncrief.
Good evening, Miss Lawson.
Lawton, thank you.
Sorry.
Yes, ma'am.
Okay. There's a question in regarding to the amendment seal of the removing of the parish, and it's just state Jamaica.
Right.
Those who still have the ones with the parish, is there a time frame for those to be changed out?
That is for Miss Oliphant and Mrs. Collins Duncan.
Yes.
Remember, I am National Land Agency, so the Justice Ministry, but I don't work there, but I recall being told that they are going to recondition the seals.
Yes.
Right.
Yes, we'll treat with it.
So, as it relates to the seals, first, JPs and most of you will have the seal that says the parish. The seal that you have that says the parish, that is still valid and legal, so you do not have to worry. The ministry has formulated a plan where we intend to implement and introduce to each JP the new seal that says Jamaica. We have over a 5-year period. We hope to complete the implementation by March 2026. We have commenced the process. We have started with the parish of Hanover and Trelawney, and now we're moving to St. Mary and Portland. I'm not sure which parish you're in, but
And Andrew.
there. You're St. Andrew?
That's correct.
Right, one of the larger parishes in terms of JPs. So we're getting to your parish, and it will occur, but you can be assured that the seal that you have now that says St. Andrew, it is still valid, and so you do not have to worry about the legality of that instrument.
Yeah, thank you very much.
Okay, the other person, Miss Oliphant, is Oscar James. Go ahead, please.
Hi, good evening, Ms. Lawton.
Good evening.
Thank you for that presentation. Very informative, excellent presentation.
Thank you.
Just 2 quick questions for you. You had mentioned about a case where one party had to sue the lawyer and the justice of the peace. I just needed some clarity on which party needed to sue, the original owner or the person who purchased the property which had fraudulent documentation.
In the cases of fraud, the purchaser, if it is a purchase of value,
yes,
a value with they are okay. The issue is always with the person who was defrauded and the person who committed the fraud.
Okay.
So the attorney at law would have been sued by the person who was defrauded.
Defrauded.
Yes.
Yeah. All right. Second question. You mentioned about the title address separate and apart from the residential address.
Yes.
If a property is
civic address.
Civic address.
Yes.
Right. If a property is associated with 2 roads, meaning it's on the corner of 2 roads, can the civic address be changed or it's permanent?
No, man, the civic address is issued by the municipal authority, aka parish council.
Yes.
They're the ones who does that. So the title would acknowledge where the property is. It will tell you, property being Tredegar Park and Longville Park. I just call it 2 random names. it will say that, but the civic address is what? If there's an issue with the civic address, you go to the municipal authority for that parish and have a discussion with them about that.
Okay.
Because the property address doesn't change.
But the civic address can change.
Yes.
Thank you very much.
Right.
The next
Okay,
person
are there
we
any?
have is Miss Pauline Williams.
Good night, everyone.
Good night.
Thank you, Ms. Lawton, for your excellent presentation. Also, Ms. Bailey. Yes, I have a question here. You mentioned, I think it's Ms. Bailey, about the lost title application. To be honest with you, I'm afraid of signing land documents. I don't know, I just, feel scared all the while when people come with titles, also they're going for titles, etc. You mentioned that it is easy for JPs to be conned in signing the applications, and you cited the person A, person B, person C scenario. Give us two or three salient points to bear in mind when dealing with the lost title application.
All right. First thing for the lost titles application. And just to say that you're not the first justice of the peace I've heard say they're afraid of land matters. First thing first, regardless of the document, do you know the person? Do you know them personally? That's the first thing, first hurdle. You cross that one. If you don't know them and they still give you the ID, as Minister Chuck said, if you are just not comfortable, you're not comfortable. Second point that you need to be aware of. When persons come to you and say, sign this for my daughter, sign this for my son, sign this for whatever, unless this is somebody you know and you know their signature and you had prior conversation with them telling you that they were going to send it and so and so to take it to you to witness it, you need to step back a little and scrutinize. Right? That's the second thing. And the third thing I will tell you, follow your instincts. Oftentimes it tells you when you're uncomfortable, it tells you that something is wrong. You may say, I'm just being paranoid. Those are your instincts. So you need to follow them. But if it is a case where you know the person, you're comfortable, that's fine. Because remember, the essence of it, why I say you can be tricked, is that persons will acquire identification in the names of people. So they will come to you with a picture of maybe a Chinese looking person, Indian looking person, the name on the ID says Charlene Lawton. And it is a government issued ID, it happens. So if this is somebody that you don't know and you are not comfortable doing it, that is your best protection.
Thank you so much, Miss.
You're
Thank
welcome.
you so much. And that was exactly what I did the last time. Somebody came to me in a rush, was going back for title, some transfer, property in the country, and a bag of things. And I was really uncomfortable, and I didn't. I told him to call a land agency to find out something and then get back to me, but it didn't come back.
Okay.
Thank you.
You're welcome.
Okay, Ms. Lawton, I hope you can assist us. We have a question from Cecil Gordon on YouTube. The person is asking, what if you're paying taxes for the land that you're occupying? A piece of land for 12 years. Will it automatically become yours?
No. So paying taxes is the first step persons go to, because as part of the application process, the property taxes must be paid up. So persons think that is the only way. It is a requirement, but it is not the only requirement. You will have to show proof of owner of possession for those 12 years. The acts that you have done, the things that you have done. So paying the property taxes alone is not enough. It is a requirement, but it is not enough. Let me tell you something. If you go to the tax office, so the tax period is April 1, to March 31. So April 1, 2022 to March 31, 2023. It runs with the financial year, with the government's financial year. If you go to the tax office and you pay the property taxes on your property for all of the period 2022 to 2023, and I turn up to the tax office the following week to pay taxes on the same property, the tax office is collecting the money. So paying property taxes alone is not sufficient. It is a requirement because you have to clear the property taxes when you're doing matters of first registration, or even if you're transferring the property, you have to clear the property taxes. But it is not the only requirement. Acts of ownership must be there. What have you done to this land for 12 years that you have possessed it? As it says, you have possessed it, you are in possession. So what are you doing? Some persons put tenants on the land. So they would have put someone on the land as a caretaker, etc. But as an aside, for your personal purposes, if you go and pay property taxes and it's all paid up, somebody is making a move. Be vigilant, be aware.
Okay, thank you, Ms. Lawton. Ms. Oliphant, we have Rhea Richards' parent. Her hand was raised for some time.
Go ahead, Ms. Parrott. Ms. Parrott?
Hello, yes, I'm here.
Yes.
I hope I can get some answer here. Thanks very much for the presentation. Ms. Lawton, you have been excellent. Thank you very much.
Thank you.
Now, my father passed away in 1997. The property was not joint ownership. So after making our inquiries, we were directed to the office. I believe that's on King Street. Is there somewhere there we can go and check on something with property, land?
King Street is tax office.
No, well, I may get it wrong. That building is next to the Supreme Court.
That's not us. Well, tell me what exactly they said happened.
But when we went there to get some document to take it to the office, that's the title's office.
Yes.
They told us that they can't find whatever was sent there for us to use.
Where is your father's land?
We are living in Spanish Town, Ebonyville to be exact.
All right, tell you what. You have access to an email?
Oh, sure.
Send me an email. It's Charlene, Chalene. You see my name on the screen?
Yes, it is there.
It's first name dot surname at nla.gov.jm.
At nla.
.gov.jm.
Okay,
so it's Charlene, no R. If you put the R in there, it will bounce. So it's CHALENE dot LAUGHTON at nla.gov.jm. Send me an email with the query.
NLA@gov.jm.
No, at nla.gov.jm.
Okay, great. Thank you very much.
You're welcome.
Okay, bye.
Okay, Ms. Lawton, before you go, we have one more question from YouTube. Dr. Ann Shaw, she's asking the question. The Electoral Office issues a letter of identity for persons who are awaiting the new IDs. Can these letters be used as identification as it relates to land matters?
As well, as far as I know, when I heard the notice, they said that the Electoral Office said that in lieu of the IDs being printed, that letter is to be supported by a letter of a letter by a justice of the peace, support identifying the person. That's what I heard. I stand corrected if it's not so. But if you know the person and they have that letter, the challenge is when you don't know the person, you know. But if you know the person and you know that they are waiting on the ID to be printed and you're comfortable, fine, because that letter would have verified that, yes, they went in, they're just waiting on the physical ID to be printed.
Okay, thank you. Ms. Oliphant, going back to the raised hands, we have General Lawrence.
Go ahead, Mr. Lawrence.
Good evening, colleagues.
My question relates to the ownership of property. You spoke about 30-year period to which a person must be connected to the property to gain ownership. Did I get you correctly?
30 years for unregistered land.
Okay. The question I want to ask then is that in a situation where you have an extended family, let us say that the mother or grandparent lived there for, say, 10 years then you have children who would have been adult then coming up after. Does it mean that the person who inherits that property in terms of living there after that person would have to start over counting, or the 10 years that it was occupied by previous generation would be added to that person's time?
There's an approach legally that is referred to as stacking. So they would have to tack on the years of the mother and the children to bring it up to the 30 years, but it can be done.
Thank you very much.
Okay, thank you. We have Mr. Blake, or is it Miss Colette Burt? Blake?
It is Colibert Blake.
Okay, go ahead, Mr. Blake.
Okay, good evening, everyone. Question to Ms. Lawton. As it relates to the Possessory Act, and you have mentioned the 12 years,
You're breaking up.
No, I'm saying as it relates to the Possessory Act for the 12 and the 30 years, am I being heard?
Yes.
Right. How do they relate to government-owned land when persons are living on those lands for those years? Could you please give information read that?
All right, so it's not the act of possession or possessory act. What did you just say?
Well, I am referring because I listened to you, so you please correct me where I'm in error.
So it's the Limitations of Actions Act. For government lands, it's 60 years possession.
Okay.
You're not going to reach 60 years.
No, I don't think anybody would live there for that. Because I heard you said the person would have to be start at 18. So 18,
right.
Beautiful.
So for
Thanks very much.
registered land, it's 12 years. On registered land, it's 30 years. For government land,
it's 60 years.
60.
Okay. Thanks very much. The presentation was very good. I learned a lot from it. Thanks very much.
Thank you.
Thank you very much. Ms. Lawton, we have a question coming from the chat from Kingsley Palmer. Essentially, it's saying that 3 persons are in a joint tenancy. One loses their mental capacity. Can the other 2 sign and sell the property?
No, they would have to get a court order under the Mental Health Act, Section 23, if I'm remembering correctly. So that is something that they would have to go to court and prove that this person is disabled. That's what we call it. It's a disability. And then no, the court would appoint one of them to act on this person's behalf. And whatever proceeds they get from the sale goes into an account for this person, because it's still their money. Whether or not they are able to comprehend that is a different story, but it is still their money. So once it's a mental health issue, as in the person has totally broken down, incapable, they are incoherent, etc., you have to go to court. So you need medical records, etc., to prove to the court that this is what is happening and this is why you need to do it.
Okay, thank you very much. I think we have maybe space for a couple more questions. We're actually wrapping up now. We want to thank the National Land Agency for their very solid contribution to the discussions. Ms. Moncrief, do we have any hands up?
Yes, we have quite a few, but since we'll be
We'll take maybe about 2 more questions.
Yes, we have, let me start with Dr. Ivana Thomas.
Dr. Thomas?
I'm here. Yes, this is Dr. Thomas. Fantastic presentation. And my question is not in regards to land or any of that stuff. It's actually a general question. I am just wondering, what level of support does the Ministry of Justice offer to the Justice of the Peace that are out there serving the country? Because as I heard the case of someone being sued, obviously because of negligence, but I mean, someone could also decide to sue, maybe for other reasons. At the end, maybe you'll be victorious, but at the same time, what kind of support do we get from the Ministry of Justice as Justice of the Peace? I mean, just curious.
Okay, thank you very much, Dr. Thomas, for that. Now, as you know, the JP is a voluntary profession, for want of a better word, right? Now, the type of support that we give is guided by what is in the Act, the Justices of the Peace Act. Primarily, once you have been commissioned as a JP, you're given an instrument. As it relates to if you become involved with the law, do we provide any support there? Unfortunately, no, we do not. But what it does allow for you to do is to engage with your customers if you should become involved with the law, and then the customer should be able to be aware of your matter, and once it is settled, then you can continue as a justice of the peace. If you're found guilty, God forbid, then there are other steps that needs to be taken, because as you know, that a justice of the peace has to be a person of unquestionable integrity. I can't say to you that we offer any other support other than to try to educate JPs on all the latest and current development in the laws, and even educate you on existing laws, just to refresh your memory. But other than these areas that I've just mentioned, I'm not aware of any other support that the ministry has at this time.
Okay, all right, great. Thank you so much. Much appreciated.
Yeah. Thank you. Another question, Mrs. Moncrief-Wiggum, the last one.
Well, the last, so we could try Paulette Kennedy, and then after Paulette Kennedy, we will try Christine Rowe.
Good night, everyone.
Good night.
Okay, I am Paulette Kennedy from St. James, and I've listened attentively to the presentation. It's a very excellent presentation. I don't have a question, but I want to just mention an experience. With regards to persons who are deceased and family members are living on the land. These situations at times are very troubling and worrying in terms of transactions. It happened that this person, a man in my community, is selling the property to community persons. And one day, one of the persons who bought a portion of the property came to me to get permission to bury a relative on the property. But when she came, she did not have a title for the property. So I asked her, where is the title? And she said she bought it from Mr. X. So I said to her, but you would have to own the property in order to get permission to bury your relative on the land. She said the owner has the property, and the owner was the one who sent her to me. I told her to go back and bring the owner. When the owner came, as I said before, it's a family property. It's a family property, and he was selling the land to individuals. I'm sorry about that interruption.
Miss Kennedy, Miss Kennedy, are you hearing me?
Hello.
Miss Kennedy,
Miss
I'm
Kennedy?
asking you to pause. And let us go on to Christine Rowe. Miss Kennedy, just give us a moment, please. Let us go to
Yes, please,
Christine
I'm
Rowe.
declining this call.
Miss Rowe? Miss Rowe, are we able to get your question?
Hearing me? Are you hearing me?
Yes, go ahead. Go ahead. Miss Rowe, we're hearing you. Okay. We have actually seen we've run out of time in terms of our question and answer section. I am going to invite Minister Chuck to come in and give our closing remarks.
Hello.
Minister Chuck?
Hello.
Ms. Davis, we are actually unfortunately out of time in terms of the time frame that we've allotted for questions. So I'm just going to ask
It's not really a question. It's not really a, well, it's just to ask Miss Lawton if she could repeat her email address again.
So it's her first name, Charlene.lawton@nla.gov.jm. Remember, her first name does not have an R in it, so it's CHALENE.LAUGHTON, as in laugh, ton.
Yes. At NLA. At NLA.
.gov.jm. And I'll put it in the chat for you as well.
Okay, thank you.
Thank you very much, Ms. Lawton. Minister Chuck, if you're able to come back in.
Okay, I want to wrap up, so I'm going to ask everyone to just turn off your audio and your video. And so I just spend a minute or two to just express great thanks and appreciation. It is quite clear this evening was a very good evening. I sat and I listened and I was so very impressed with the presentation and the agency. Thanks to Ms. Charlene Lawton and Ms. Sarah Dash. I think you did an excellent job, and I can tell you, I've got a lot of comments really emphasizing how well you present, both of you presented, and also how much they learned this evening. I know that what is even more significant, the number of persons on YouTube who were able to send in information and also to express appreciation for the presentation. May I also thank my team at the ministry, headed by Ms. Oliphant and Ms. Wigan, and also Ms. Collins Duncan. Thanks also to Bishop Pitkin and Ambassador Maureen Van Steern, who came during the course at the beginning. Justice of the Peace, it was a very good evening. One, Dr. Thomas asked towards the end there what support the ministry will have for GPs. I think it is important, Justice of the Peace, to be a part of the parish association. Get in touch with the Custos because the Ministry of Justice will be working closely with the Custos and the parish associations. The parish association represent all JP, and I will be working with the parish associations to whatever assistance, not necessarily monetary, but to ensure that the JPs give as much support. And quite frankly, as Ms. Wigan pointed out, the real support we want to give is to edify you some more, widen the scope of your knowledge, put you onto information which you may not be readily available, And therefore, it is important that you be a part of the parish association and keep in touch, as we have many more of these sensitization programs. As all of you can see, it was oversubscribed. We had over 1,000, sorry, we had 1,000, and then no one else could get on. So I have a lot of persons sending me WhatsApp to say we need another platform that can accommodate more than 1,000. But our platform here only accommodate 1,000, and that is why we opened up to the PBCJ, YouTube, and our ministry online. So over 600 other JP joined us online and on YouTube. Now, Charlene and Mr. Sarah Daly, the truth of the matter is that we have over 9,000 JPs. So both of you will have to come back again at another time. Okay. What we're going to do is we have recorded the presentation this evening. We might do a bit of editing and put it on the ministry's website, so any GP can actually listen to the presentation. We'll indicate around to the custodies and the parish association that the excellent presentation this evening will be preserved on the ministry's website. But it has been a good evening, Justice of the Peace. I'm so sorry to keep you so late, but I'm sure you really benefited from the presentation, and I hope you will look forward to further presentation during the course of the year. As I intimated at the beginning, we're going to be pushing throughout the year alternative dispute resolution. I will be in St. Elizabeth tomorrow, and I will speak a bit on it. But during the course of the year, you will hear a lot more presentation on restorative justice, mediation, child diversion, and victim services. So thanks again for joining us. Keep in touch, provide the good service to your communities, and God bless all of you as you serve our country.
Thank you, Minister Chuck. God bless you too.
Thank you all, everybody. Keep safe.
Thank you, guys. Thank you. Have a good evening. Bye-bye. Thank you all. God bless.
Thank you.
Thank you.
Thank you.